Ready to sit down? I'll sit down. Yeah, I have one.
Okay, can we bring the defendant out? Yes. No, the defendant.
Yeah, he's right here.
All right, yes, bring him out, please. All right, is Mr. Villarreal printing copies? Can you show the video, please? Thanks. All right, we're going to go on the record. In 2021 CR 1804, State of Texas versus Alexis Morganfield. Can I have parties announced for the record for the state? For the defense?
Ken Stevenson and Anthony Cantrell with it.
All right. And we had discussions off record in regards to State's Exhibit number 7. Have both parties had a chance to re-review State's Exhibit number 7's defense?
Yes, Your Honor.
And there were some redactions that were made. Any objections to State's Exhibit 7 being offered with the redactions that were discussed off record?
That's what this is. No, Your Honor.
So are there any objections to State's Exhibit number 7 being admitted? Defense?
No, Your Honor.
All right, then State's Exhibit number 7 is admitted.
And just for purposes of record, Judge, the original State's Exhibit number 7, I have marked 7A. That is the unredacted version. And for purpose of the record, obviously, this will not go back to the jury or anything like that. I just want the record to be clear, just so that this Act 7A does not go back to the jury, just Exhibit 7.
Yes. All right. And where we left off yesterday, the state had rested defense. Are you ready to proceed?
We're ready. We're ready.
All right. And defense, are you calling witnesses?
Yes.
All right. If you could bring the jury in.
You want Sarah? Yes. Can we put the first
Yes.
one?
Yes. Mahia, you're on it. You are. And then once she takes the stand, you can put the video back on. Caroline, you're on it too. Yes.
All right, for the jury.
All right, everyone, please be seated. Yes. All right, defense, call your witness.
At this time, the defense will call Sarah Underano.
All right, you are still under oath. Do you understand? Yes. All right, defense.
Good afternoon, Sarah. My name is Anthony Cantrell. Thank you for coming here again today. I would like to go over some statements that you have made previously. And I'll try to go in chronological order so that you can basically answer yes or no to these questions. Okay.
Okay.
First of all, let me focus on Jada King, right? You learned how did you learn of Jada King?
When he messaged me on Instagram.
Did you first learn of Jada King through Sterling Green when you were in the Justice Alternative School? From
No,
Sterling Green.
no,
Did you and Sterling Green ever talk about Jada King when you were in the alternative school?
not that I remember. No,
Did you could it be that you did do that thing, or you just don't remember?
I just don't remember.
Who is Sterling,
He was a classmate at Juvenile Justice Academy.
and how was he related to Jada King?
I believe they're family of some sort.
Could it possibly be that he was his brother?
Yes,
So was it after the Juvenile Justice Academy that you started receiving some type of digital messages from Jada?
yes.
How many messages were there?
I don't remember.
Was there more than 10?
Probably yes.
And how long did that messaging between you and Jada King and yourself continue for a time span?
I didn't respond to him until March 29th. From what I remember.
So the first time you ever spoke to Jada or digitally message, and I'm gonna call it DM just for easy purposes. The first time you DM'd Jada King was on March 29th.
From what I remember, but I can't say for sure.
So are you telling this jury that on the first message, and you can correct me if I'm wrong, on March 29, 2020, the first time that you DM'd Jada King, you would want to go meet up with him?
Yes.
What was the purpose of you and Jada King? Why were you going to meet up
To hang out and smoke
and smoke what?
marijuana.
How did you know that he smoked marijuana?
I believe he asked me if I wanted to smoke.
And that was during that day?
Yes.
So when you talked to your mother, you did not tell her that you were going to meet up with Jada King and smoke marijuana, did you?
No.
So that was not truthful. When you talked to your mother,
No.
because you told her you were going to do what?
I just told her I was going to hang out with a friend.
So that wasn't true. Jada King wasn't your friend yet. You had never met him.
Then no, it wasn't truthful.
Now, did you also learn from Sterling Green that Jada King had a reputation that if girls would not sleep with him, have sex with them, that he would throw them out of the car?
Sustained.
I don't remember. Sorry.
Once someone makes an objection, I'll make a ruling on that objection. If you don't understand what my ruling means, just ask. You're going to ask me whether or not you should continue to answer the question or not. Do you understand?
Yes.
All right, defense.
Did anyone ever tell you that Jada King had a reputation that if girls wouldn't sleep with them, that he would literally kick them out of the car?
Object irrelevant.
May I approach your honor?
Yes.
So on March 29th, 2020, did Jada King pick you up?
No.
Who picked you up
Alexis.
and who else?
I didn't know the names of the two others.
So it's 3 people.
Yes.
Did you know who they were?
No.
Had you ever met them before?
No.
So you got into a car with 3 complete strangers.
I didn't realize that they weren't Jada King until after I got into the car and after we left.
Well, before you got into the car, certainly you would have looked into the car and seen that Jada King wasn't there.
Well, no, I didn't see him.
So you knew Jada King wasn't in the car, right?
That'll be overruled.
You may answer.
I didn't look inside the car, no.
Did you realize when you went into the car that Jada King was not there?
Yes.
Did you ask to leave?
No.
So you willingly went into a car, and then once you realized Jada King wasn't there, you still went into the car with 3 complete strangers.
Yes.
Once you, where did you go after you got into the car with 3 complete strangers?
To Jada King's apartment?
Did you ever go inside Jada King's apartment?
No.
Did you meet Jada King?
Yes.
Where did you meet Jada King?
Outside of his apartment?
Did you have a conversation with Jada King?
Yes.
What was that conversation about?
It was in the vehicle. We didn't really talk much before we got into the vehicle.
What was the conversation? And which vehicle did you get into?
Alexis's vehicle.
And describe that vehicle.
I believe it was either a black or gray car. I don't remember for sure.
And it was the driver that you're calling Alexis, right?
Yes.
He was driving.
Yes.
And what was the conversation? Oh, by the way, once you got there, what happened to the 3 people who were there? Were they still in the car?
No, they got out the car.
And did you have a conversation with Jada King in the car?
Yes.
Where in the car?
In the back seat.
And what was that conversation about?
About him wanting me to have sex with him and me saying no.
Right? And what happened next?
And he eventually got out the car.
And did he leave?
Yes, back into his apartment.
Did you learn that Jada King had an ankle monitor?
Yes,
And how did you know that?
because I saw it.
Did you ask him about it?
Yeah, he told me he was on house arrest.
So let me see if I have this straight. You go and meet J.D. King the first time you ever talk to him. You lie to your mother about going there. You get into a car with 3 complete strangers. And then you meet up with J.D. King and you know that he has an ankle monitor and he's under house arrest. Is that pretty much summed up what you testified?
Yes.
After that, why didn't you ask J.D. King if you could use his phone and try to get a ride home or some other way to get home from someone else?
I don't remember. I didn't talk to him for a very long time.
But once you realized that you weren't going to hook up with J.D. King, why didn't you make an effort to call someone to pick you up?
I don't remember.
Is it because you didn't want to?
No.
Did J.D. King tell you that these 3 guys are going to want something from you if they're going to give you a ride home?
He said he didn't know if they would give me a ride home.
Did he tell you that these 3 guys would maybe want something from you if you're going to get a ride home?
Yes, he implied it.
And you still chose to go into the car with these 3 guys?
Yes.
And was the reason you decided to go into the car with these 3 guys is because you wanted to smoke weed?
Probably, but I don't know for sure.
Did you go into this car knowing that they were going to go get some weed somewhere?
Yes.
And when you say weed, what is that?
Marijuana.
And you know marijuana is illegal, correct?
Yes.
From the time you leave with these 3 guys and go to a place where they, did they ever get marijuana?
Yes, I believe so.
And how long did it take for them to get the marijuana?
From what time?
From the time you left J.D. King's apartment?
Probably about 15 minutes, 20 minutes.
And at that point, when they stopped to get marijuana, did all 3 of these people leave the car?
Yes, from what I remember.
And you were in the car by yourself?
I
You were
think
in the car and then you left the car.
I got out of the car with them.
And did they leave you? In other words, you didn't follow them.
We just stayed outside the car and waited for the person to come out to the car, from what I remember.
And they did not go and leave you at that point?
No.
Okay. So when they got the weed, what happened next?
We went to another apartment complex.
And is this the apartment complex where the 3 people left you alone in the car?
Yes.
And at that point, had y'all smoked weed already?
No, we never did.
Did you, were you left alone in the car after you got to that next apartment complex?
Yes.
And how long were you left alone?
A minute or 2.
You could have freely left at any point during that minute or 2 if you felt you were in danger or otherwise, correct?
Yes, correct.
And this is also knowing that J.D. King had told you that these 3 guys might want something, they're going to give you a ride home, correct?
Correct.
But you insisted to still stay there with them, is that right?
Correct.
So the 3 people came back, or is it just one of the people came back?
1.
And that one person is what you're claiming is Mr. Morganfield, is that right?
Yes.
And Mr. Morganfield came in, and where did you go in the car?
in the back seat. I stayed in the car, so
And you were in the back seat the whole time?
yes,
And Mr. Morganfield? And Mr. Morganfield came in the back seat with you?
yes,
And this is the time period where you've alleged that Mr. Morganfield asked you to give him oral sex,
yes,
and you told in your statements to Officer Sandoval and as well as to Detective Benavides that with respect to Benavides, he didn't force me, but I gave him oral sex. Is that right?
yes,
And then you also told Officer Sandoval I gave him oral sex. He didn't force me. Correct?
correct,
So you said that to two different police officers after this event had occurred. Correct?
correct,
After you gave who you claim to be my client, Alex, oral sex, you asked him to give Brandon a call. Is that right?
I asked if I could call Brandon off his phone.
And did he call Brandon for you?
I believe I did.
So you did use his phone and called Brandon.
Yes,
And did you tell Brandon to pick you up?
yes.
And you're the one that told Brandon where to go.
I told him I would send him the address, and then he took the phone away from me after the call.
Okay. And did the address get sent?
He sent him the name of an
The
apartment
apartments?
complex, but when it was a very vague name. There was a lot of different apartment complexes that showed up.
Okay. So who you claim is Alex did call Brandon or give you the phone to call Brandon and give him the name of the apartment complex.
I don't know if it was the right name, but
Okay.
yes, he gave him a name.
All right. So at that point, did the three people say they were going to leave you and they were going to leave and did you insist on staying?
I didn't want to get out the car at first, but then I eventually got out the car.
Okay. What was the reason you were going to get out of the car?
Can you repeat the question?
Sure. Why did you get out of the car at that point?
Because they told me to get out the car.
And did they tell you they were leaving?
Yes,
And did you tell them that you didn't want to be left there, that you voluntarily got back in the car with them?
they came back and told me to get in the car, and then I got back in the car with them. Yes.
You didn't have to get back in the car, did you?
No, I did not.
So you voluntarily went back in the car.
Yes.
Okay. So let me just recap the testimony and tell me if I'm incorrect. You met Jada King for the first time. Three strangers picked you up. You learned that Jada King was on house arrest. You went to an apartment complex to pick up weed with these three people that you don't know. You had opportunity to leave at least one time. You had given voluntarily oral sex to who you claim is my client. Then you were given an opportunity to call Brandon. You got out of the car. You could have waited for Brandon, but you chose back to go back into a vehicle with these three strangers that you had met the first time, even after one of them, you had already performed oral sex on one of them?
Judge, I'm going to object to leading in a compound question.
All right, the objection to compound question will be sustained. The objection to leading is overruled.
Did all those things happen?
Correct.
Shortly after that, you went into the car and went to a gas station.
Yes.
And at that gas station, you asked for help. Yes.
Yes.
Did you get help?
Yes.
What did you do?
I used a stranger's phone to call my friend Brandon to pick me up.
And did Brandon pick you up?
Yes.
Did the people at the gas station ask you if you wanted to call the police?
Yes.
And what was your reply?
I said no.
All right, let me back up just a little step. This person that you claim is Alex, prior to going to the gas station, did he ask you if he could get back in the car with you a second time in the back seat?
When I was at the gas station,
Before that, I had skipped that part. I'm sorry.
um,
Let me rephrase. Did Alex, the person you called Alex here, did he ask to go back into back seat with you a second time prior to you going to the gas station?
yes.
And was your response, yeah, sure?
Yes.
So you invited him a second time to go back in the back seat.
I believe he invited me.
He invited you to go in the back seat,
Yes.
and you voluntarily did that.
Yes.
And this is after you had performed oral sex on him.
Yes.
And is this the time that you started making out with him, kissing him?
He started kissing me.
Okay. Did you reciprocate the kissing?
I don't think so. I don't remember.
Okay. So you just don't remember. You could have, but you don't remember.
I don't remember for sure.
So then at that point, shortly afterwards, and this lasted for about 30 minutes, right?
Yes.
In the back seat the second
Yes.
time. Did you ever tell him like, get out of the car or anything like that? I'm done with you or anything like
I
that?
said no, but I did tell him no, stop it.
Okay. And he did not hurt you physically in any way, did he?
No.
Now, let's get back to the gas station. At that point, you called Brandon
Yes.
and he picked you up and took you home.
Yes.
When you got home, who did you talk to?
I called my sister.
And your mother? You talked to her?
I talked to her briefly. Yes.
And you explained certain things to your sister.
Yes.
Did your sister advise you to call the police?
Yes.
And did you call the police?
I asked my sister to call the police.
You did not call the police.
No.
You could have,
Yes.
but you didn't.
No, I did not.
After all this had happened, did you start? Oh, let's talk a little bit about which officer, if any, contacted you after your sister called the police?
Detective Benavides.
Was there an Officer Sandoval who possibly did that first?
Possibly, but I don't remember for sure.
Sure. Do you recall a police officer, probably in a
regular San Antonio Blues type uniform come to your house?
On March 29th.
I'm not sure if it's on the 29th or. Yeah, on March 30th, it would be after midnight.
Yes,
And did he talk to you about going to the hospital to get a SANE exam, a sexual?
yes,
Okay. Did you follow his advice and go as soon as possible?
I went in the morning, yes,
Okay. Did he tell you you have up to 5 days to do that?
yes,
And so you went in the morning.
yes.
Was it about 18 hours later?
No, I would say less than that.
Okay. Did you do everything possible to preserve any type of evidence that they may have had?
Yes.
And tell the jury what you did to
Um,
preserve evidence.
I didn't brush my teeth. I didn't shower. I didn't eat anything.
No mouthwash?
No,
So you testified that my client allegedly kissed your cheeks, your mouth, your neck, and your stomach. Is that correct?
yes,
And you wanted to make sure those areas were preserved so that no DNA would be missing?
yes,
And is that something that Officer Sandoval told you to do?
yes,
And also on your breast, right?
yes,
So you made sure that nothing would be, to the best of your ability, that nothing would be destroyed.
yes.
Did you learn of the DNA results from anybody?
I don't think so, no.
Nobody told you that all the DNA results taken were negative pertaining to this man?
I believe someone did, but I don't remember who it was or when.
So after March 29th, well, let me back up a step. Prior to March 29th, did you ever digitally message Lil Wally?
No,
Did you do that after March 29th?
yes,
Did you start putting disparaging remarks on Lil Wally's web page, Instagram page, or whatever you might have?
yes.
What are some of the things that you wrote on there?
I remember just calling him a rapist, saying that he sexually assaulted me. I don't remember exactly what words I used.
Okay. And they were very damaging words. Would you agree?
Yes,
Did you know that he was a rap artist?
yes, I figured out from looking at his Instagram, yes.
Did you look up Jada King's profile prior to March 29th?
Not that I remember, no.
Okay. So you only looked up Jada King that one day?
Whenever he first started messaging me, but that could have been before, I don't remember.
Understood. So you never looked up Lil Quali. Sorry, these are a little tough for me. You never looked up Lil Quali's profile.
No,
But after this day, how many times did you get on the internet and try to disparage him?
a couple times.
Just a couple?
From what I remember, yes.
Did you tell any of your friends to get on his page and disparage his reputation?
Not from what I remember, no.
Could you have?
I could have, yes.
Did you ever get a response from my client regarding your disparaging remarks?
I probably did, but I don't remember.
Didn't he reach out to you and tell you that I didn't do this to you? I don't know why you're saying this about me. I'm sorry, or something to the fact that, please stop disparaging me. Did you never get something like that from him?
I probably did, yes.
You did?
Yes.
And wasn't your remark, and did he offer you some compensation because he felt bad
He offered me compensation before that,
before what?
before I posted anything about him.
Okay. Was your response that $100 would not be enough, you would have to pay more?
Probably, yes.
So what you were saying to him is, if you want me to stop doing this, you're gonna have to pay me a lot more money?
I don't remember saying that, no.
Well, when someone tells me $100 isn't enough, you need to pay more, that sounds like you need to pay me more
I
money.
think I meant like he needs to pay, like, not literally money. That's what I meant.
Okay, but that's not what you said. You said he needs to pay more money. More than 100.
I'm thinking of the video call. I'm not remembering anything other than that.
Understood. Did you ever make a fake profile of Little Quality to promulgate your revenge, whatever you want to call it?
No,
You never made a fake profile?
no.
Okay. Thank you very much, ma'am, for your testimony.
State?
Pass the witness.
Thank you, Judge. Sarah, this happened over 2 years ago. Is that fair to say?
Yes,
And is it fair to also say that your memory at the time this was occurring was probably better than your memory today?
yes.
So I want to talk about a couple of things that Mr. Cantrell talked about in your direct examination. First I want to talk about is he mentioned that, and he asked you, marijuana is illegal, right?
Yes.
Okay. Did you actually pay for any marijuana that day?
No.
Was Alexis Morganfield with you when you went to the marijuana dealer?
Yes.
Is he the one who drove there?
Yes.
So it's illegal for him too, right?
Yes.
So he also talked about let's say that you lied to your mother about going out that night. What did you tell your mom about going out that night?
Didn't tell her much. I just said I was going to hang out with a friend.
Okay. Did you go hang out with somebody you thought was your friend?
Yes. All right. I didn't really know him. So
I mean, were you saying you were going to do something and then you went and did something else?
no.
So you're going to hang out with some people, right?
Yes.
So it's not like you're telling your mom, I'm going to go eat and then you go to the movies, right?
Yes.
So Mr. Cantrell also asked you, and he used the word insist. You insisted staying there with Alexis Morganfield. Did you insist on staying there with him?
No.
Okay. And did you want to be there with Alexis Morganfield after he put his penis in your mouth?
No.
So if you could have left, would you have left?
Yes,
Mr. Cantrell talked about two statements that you made to police. One to the initial reporting officer, Officer Sandoval, and then one to the follow-up detective, Detective Benavides. In both of those, he likes to point out that you used the phrase "didn't force me." What did you mean by that?
he didn't use like physical force, but he coerced me. He kept asking and I said no, and then I chose to do it after.
So it's fair to say he didn't use any physical force to compel you to put his penis in your mouth, but did you do that voluntarily?
No,
And you realize at the time of this offense, you were how old?
16.
You realize that's not the age of consent in the state of Texas, right?
Yes, I
So
do
You can't
realize.
even consent to this, right? But Alexis Morganfield, who's 19 at the time, over 3 years older than you, he can consent with another consenting adult.
Yes.
Last thing I want to talk about is, and with what Mr. Cantrell ended on, and that is paying more money, this conversation that was marked in State Exhibit number 5. In that conversation that you had with him, he's the one who offered to give you money, right?
Yes.
Did you ever ask for money from him?
No.
When you said he needs to pay, or you need to pay more, are you talking about money?
No.
Did you ever take any money from him?
No.
Were you aware he even had any money to give you?
I'm sorry, can you repeat that?
I'll retract that question. When you said that back to him, when he offered you $100 because he was sorry and he felt bad about what happened,
Objection, that was not what he said. He said, she testified earlier that she didn't know what he felt bad for.
All right, that'll be overruled. You can ask your question.
when he said he said he was sorry and he felt bad for what happened and he offered you money. After that, did you ask him for more money?
No.
Did you ever take any money?
No.
And I should say, I have just a couple more questions. Mr. Cantrell, both on your cross-examination yesterday, as well as your direct examination today, talked about your opportunities to leave. When you were at any of the apartment complexes, did you have any contact other than the 3 people that picked you up that day with Jada King?
No, not other than the drug dealer.
Okay, so those people, all of the 3 people that picked you up in the car, right?
Yes.
Including the defendant,
Yes.
their friend Jada King,
Yes.
and their drug dealer.
Yes.
Did you have any interaction with any other people that day, up until you go into the gas station?
No.
So not having a phone, not seeing anybody else, not interacting with anybody else, did you have the opportunity to ask for anybody for help?
No.
When he was, like, when he was kissing your breast and touching your vagina over your clothes and kissing you after he put his penis in your mouth, you said you were crying?
Yes.
And did you continue crying the time during that time that he was doing it to you?
Yes.
Did you also tell him no during that period of time?
Yes.
And despite all of those things, he continued touching your vagina and touching your breasts?
Yes.
And do you remember about about his reaction to saying that you wanted to go home?
He didn't want me to go home.
ahead with it.
So I'm a little confused. I thought you testified and you told two law enforcement people, and you just testified under oath that you voluntarily gave allegedly my client oral sex. Is that right?
I said I wasn't forced physically.
Okay, so you voluntarily did it, right?
Yes.
And even after the first time you had given him oral sex, he asked that if he could come back in the back seat with you, and you said, yeah, sure.
Yes.
So that doesn't sound like you're upset and crying, especially after you're in that for 30 minutes.
I was crying after I went into the vehicle with him the second time.
When you and him were making out,
Yes.
and he was kissing your breast,
Yes.
your neck,
Yes.
your stomach,
Yes.
and I think you testified when the state was asking you about the oral sex, you testified, I chose to do it. Isn't that right?
Yes.
When you talked to my client after March 29th, and you had posted all those things about my client being a rapist, he told you that I'm not the person who did this, didn't
Your Honor,
he?
I'm going to object, call for hearsay.
Could you repeat your question, please?
Sure. What did my client tell you with respect to he either was or was not the person that did this to you?
I'm going to object, call for hearsay.
That'll be sustained.
What did my client tell you when you were talking to him about stopping the negative post after March 29, 2020?
Your Honor, I'm going to object to hearsay.
What?
All right, can I have parties approach?
Sure. My client never apologized to you that he did this to you. Isn't that right?
No, he never specified.
But he did specify that I did not do this to you.
I'm going to object again to hearsay and ask and answers.
All right, the objection to asked and answered will be sustained.
Do you remember him specifically saying, I'm not the person that did this to you?
Again, Judge, same objections.
Sustained.
Do you remember? It's a little different, Your Honor.
I mean, you can ask whatever question you want, and then I will make whatever ruling to any objections that are raised.
Well, that's the question I just answered. Do you remember?
Right.
That's different from, did he tell you that?
Right, the objection is sustained.
Did he tell you to please stop posting these negative things that you were posting?
Yes,
Did you?
I don't remember. I don't think I did.
Asking her direct. I'm trying to get it. Help you. Did my client admit to doing this to you?
No,
Pass the witness.
I have no further questions. For the witness.
All right, is this witness excused?
They would ask that she be excused.
She can be excused, Your Honor.
All right, again, the rule has been invoked. You're not allowed to discuss your testimony with anyone except for attorneys for the state and the defense. Do you understand?
yes.
All right, you may step down.
Your Honor, can we have a short break?
All right, ladies and gentlemen, I'm going to give you a break. We will be back here at 2:45. Remember, you've heard some evidence in this case. You're not allowed to talk amongst yourselves about it or talk to anyone else, or do any type of investigation. Does everyone understand? All right, everyone, please rise for the jurors. All right, please be seated. You can, give us- All right, Alfonso Cabanas, your client is in custody, is that correct?
Yes, Your Honor, he is.
All right, just give us a moment and the deputy will bring him out.
I guess he'll still want to speak to his client, but we're gonna ask for a short recess so we can reach out to our victim.
Okay.
We don't need a long one, like 1 or 2 weeks.
All right, let me see if I can get the clerks here. All right, what? Oh, we can have the video on. Could I have Marissa Captain Contreras, please?
Okay.
Oh, and just the five. Yes, thank you. I'm trying
I
to,
don't know what video I'm doing, Judge.
thank you. You're just doing it all. I so appreciate it. Thank you. Okay, on Contreras, how much time are you asking for?
Sometime. 2 weeks, sir. Exactly. No more.
Oh, okay, no problem.
Did he ever tell you he didn't?
She's here.
You have a keyword.
All right, Norma, I need a reset on Luis Contreras, 2 weeks, please. All right, we're going to come back on August 30th.
Thank you, Judge.
Yes, Your Honor.
All right, Mr. Contreras, we're going to be back on August 30th.
Please specify that I did not miss you. If objected, I answered. What was it answering?
Yes.
Judge.
That's
You're actually a good friend.
He didn't answer. I kind of-
my
Yes.
comment notes.
I refer with Mr. Escobar. Out of state.
Before
Mhm.
that,
You have an NCIC.
Okay, awesome.
Let's see what was asked and
For
answered.
some reason, it's not letting. me, right?
Okay, you can just tell me what it is, but I also need your motion. All right, then I'll need a B page from the back. Can you have the B page?
She was okay.
And
The one right there.
let the clerks know I need one of the clerks on here. Thank you.
Attorney objected.
No problem. And Norma, I need Miss Starling back. And Mr. Oldestor.
That we tried to ask him.
that right here. Oh, she. didn't
Places
need
that
to.
are deep that we want there too.
Is it still there? I can't read.
Oh. Keep going before. Down. After
Prior.
or
He did put
out?
prior summary. Started.
Mm.
Okay, now we can- Yeah. all right. This is the state's.
Yes.
Go back to modern.
So what are you all in agreement to?
Judge, obviously I didn't ask him about a bond amount he agreed to. But I can ask him about.
All right, you want to talk to somebody about an agreed bond amount?
Yes.
And is somebody available to confer with Ms. Starling on her case,
Before the money.
on Starling's case?
I'm on my docket anyway. Yeah, I'll look at it. I'll talk.
I'm watching. Oh, we're, so there's a drug code that we're gonna pay on in the.
Okay. I'm not, I'm not saying that's not a possibility. I just, you know, about it. I don't.
Right. But we have only a couple stories, like, she was on probation for a couple of months.
We agreed to 10,000.
All right, and with regards to the new number one, is there no contact?
Yes,
And,
I don't know that name right now.
all right,
Sorry.
is anybody able to look up to see who the?
Let me see if I can get
Okay,
it. I might.
and I'm sorry, what did you say the bond amount?
$10,000.
And Norma, if you can contact the attorney on McKnight, it's cause number 2018 CR 11426W. We'll need a setting for that.
Isaiah, right? Yes. Isaiah Marquis. Okay.
Oh, it's the second. So our case is, I think it's being TIC, but it's awaiting PSI on the drug case. I don't think the drug case.
Yeah, and that's what I noticed. Too, like, I think only one of them was that, and they weren't like kept together because it wasn't clear from the record that they needed. And I don't know if the PSI was already done. At that point, but I was hoping for it.
I think it's a Jew.
Judge, I do have a name that's kind of long, but it's Myronisha,
Yeah.
Myrenisha, and then last name Clark, CLAR.
Oh,
Thank you, Judge. I appreciate it.
you're welcome.
All
All right, defense, are you ready?
We're still looking for the question that was asked and answered. We're having trouble finding where it was answered.
Okay, so where, are you calling your next witness? What are we doing?
We're finding out whether we're done with the witness we were just with, because we were told that the question we needed had been asked and
All right.
answered, so we're trying to
What do
find.
you
Okay.
remember on that? If you don't mind?
That it had been asked and answered on direct / cross-examination from you. And I consider yours cross-examination, even though you call her as a witness. But it had already been asked and answered on your part.
And what was it? Because he and I can't remember the statement. I can't remember that either.
That
It was yes.
that the
answer.
defendant had denied that he, that on the alleged phone call after the whatever, that the defendant had denied
Yes.
that he did. So
I mean,
that's
if you
already-
want to recall her again to,
If it's already in there, then we should.
because that's what I recall hearing.
Okay.
You have time to run to the restroom.
Yes, you do.
He gets up there, he's gonna answer the question.
Right. And the cross-examination.
I wouldn't either. They all reviewed tonight.
I want to send to the back of the jury charge. I'm gonna need. um, 6 copies. And so I'm gonna send that now.
Which you
thank
would
you.
not have the results you think it would. What would happen? You found it from the courts. You had the right to not have, you had the right to answer the question. You were trying to. They have.
That's
some-
Martinez. And Gelman, is that James Otisdorf?
The more name is not put on the-
Oh, it is.
All right, Norma, I need James Otisdorf back here now, please.
But the truth. Do that. That doesn't work. That's right. That's bad legal advice from somebody who's not one. Got it.
Yeah, why are you? Mhm. Okay. All right, so where are we, defense? Because the jury's coming back in 5 minutes.
We're not. We still need to ask for directed verdict.
Yes, Your
All
Honor,
right.
based on all of the evidence that has been
Okay,
presented
we're not on the record yet.
on the record. Okay,
Yeah.
when we're back on the record, we do need to leave.
All right. Are you ready?
Yes.
Judge,
Yes,
do you plan on closing today?
yes.
Are you gonna let them come back and deliberate tomorrow, or,
Oh, no, they're going to deliberate today.
oh, they are?
Yes.
Your Honor, if they're going to deliberate today, is that going to be over jury instructions that we haven't agreed on yet?
Oh, we're gonna do quick answer the jury instructions. I know what the defense is asking for. I think the state wants the basic charge. All right, we are back on the record outside the presence of the jury. But you have not rested. Are you intending to rest and close, defense?
Yes.
Defense resting.
All right, so what we'll do is I'll hear your argument on that after you've rested and closed.
Okay, defense resting closes, Your Honor.
Well, no, you have to do it in front of the jury. So as soon as they,
That was just practice, Your Honor.
all right, I love the practicing. That's great.
Sounded good.
Okay. And how long do you anticipate your argument is with regards to the directed verdict?
Not long.
All right, so what we'll do is we'll have you rest and close in front of the jury. Then we'll have you approach and you can make your argument on the record.
Are we? I'm sorry, Judge, I don't mean to nitpick, I'm trying to time frame in my mind. We're gonna do that at the bench, or we're gonna excuse the jury for them to do that?
No, we're gonna do it at the bench as far as the directed verdict.
Okay,
And then what I'll do is then we will do closing. But I'm giving you guys the charge now.
okay, I'm sorry, I didn't.
Oh, that's okay. And we're gonna address the issue of the charge now. And do you have a print me just one more? I'll make sure that you have one as well. So I sent out an email to both of you all with regards to the jury charge, and I know that the defense, you're still going to be asking for the age part, correct?
We are, Your Honor,
All right.
based on the argument.
We're going to go on the record,
That's fine.
then I can hear your arguments.
That's fine.
All
We're
right.
gonna make it yet.
So we're back on the record. Defense, it's the court's understanding that you are going to rest and close once the jury is reseated. Is that correct, defense?
It is correct, Your Honor.
All right, so the court has tendered, based upon what you're telling the court has tendered all parties the charge of the court. And the court emailed the charge of the court to both the state and the defense last night. State, do you have any objections to the charge?
Not as written, Judge.
All right, defense, do you have any objections to the charge?
Still reviewing the charges, cannot
Yes.
answer. We do have,
It's not in here.
okay, then we do have objections, Your Honor.
All right, and what is your objection?
Reviewing the remainder of it. Just give us a few seconds if you would, please.
Yes. Yes, it does. Right here. Same as those two. Not two.
Your Honor, we
Yes.
object to the charge of the court because it does not include the jury instructions on the defense of 3 years age difference for sex assault of child and for indecency with a child.
All right, and would you like to read into the record which section you're speaking of?
Just a moment, Your Honor. Let me find, I need to find here.
Page 6, 7, and 8.
That should be present in page 6, 7, and 8, Your Honor, where the language of the statute is presented.
All right, and what statute are you referring to so that the record can be
That's fine.
clear?
With regard to the sexual assault statute, we're referring to Texas Penal Code, section 22.011, paragraph E. Starts out, it is an affirmative defense to prosecution.
All right, and then what else would you like in the charge?
The second objection would be to the second and third count, where the charge is indecency with a child. We would be relying on Texas Penal Code section 21.11, paragraph B. Again, it is an affirmative defense to prosecution, and then it presents defense based on age, relative age.
Okay,
We have statutory support, and we have presented a brief to this honorable court to the effect that it belongs in there, that it is a question that the jury is entitled to consider.
all right,
And we
and
would
is that
ask for
as
that
to
answer.
count 2 and count 3 only, or also count 1?
Referring to count 1 should have the instruction based on Texas Penal Code 22.011 paragraph E. Count 2 and 3 should have the instruction based on Texas Penal Code section 21.11B. Your Honor, Texas Penal Code section 1.06 titled Computation of Age provides simply that a person attains a specified age on the day of the anniversary of his birthday, which would mean that a person who has attained their 16th birthday but not yet their 17th birthday for all penal code purposes is 16, and a person who has attained their 19th birthday but not yet their 20th birthday for all purposes within the penal code is 19 years old.
All right,
That's the Court of Criminal Appeals. The Court of Criminal Appeals has decided that in 2 different opinions. The most commonly referred one is Phillips v. State, 588 Southwest 2nd, 378, Texas Court of Criminal Appeals, 1979. And there are 2 district courts of appeals, the 3rd district and the 10th district, who have differentiated this 3-year defense from the general statute in Penal Code 1.06, but all the rest of the other 12 circuits of 14, or not circuits of districts of 14, have not deviated from Phillips. So Phillips would still be controlling law here in the 3rd district, and therefore it would be controlling that this case is about a 19-year-old and a 16-year-old, and 19 minus 16 is not greater than 3.
all right. State.
Judge, we have provided case law directly on this point. That's both of those cases, I believe, or 3 of those cases are briefed within Mr. Stevenson's response. There's a difference between the age in determining whether somebody is a victim versus the difference in age. It clearly says no more than 3 years. He is more than 3 years older than the victim in this case. Plain reading of the statute is clear that this would not apply to him, but the state has also provided direct case law in a published opinion, an unpublished opinion, and a fourth court of appeals case that touches on this issue as well. And so, based on all of those things, it's improper to give this type of instruction on this case due to the testimony, which is uncontroverted in this case, that the defendant is over 3 years older than the victim.
Your Honor, the one case that was presented that was out of the Fourth District Court of Appeals is not applicable to this situation.
All right.
It is not on point, Your Honor. The
All
ones on point, we believe, are listed in the brief, and because we are not in the third district and we're not in the 10th district, Phillips and Penal Code 1.06 should still be controlling law.
And we'd ask
All right.
you, Mark, your brief as to be included as part of the record.
Ask for that.
Mark the brief to be included
Okay.
as part of the record.
Yes, Your Honor, we do ask that this 3-page brief, which I've submitted to the court, be included as part of the record,
Record as far as your argument is concerned?
the record of this case, Your Honor.
Yes, there's state any objections that are being included as a part of the record, not to go back with the jury, but just as a part of the record for any purposes of appeal.
No, Judge.
All right. And you'll need to have that file stamped with the clerk so it can be included.
May I approach?
Yes. Just file stamp it, and then once it's file stamped, then we'll have it marked for the court reporter. And we could just have that marked as I think the defense, what number are you on?
Exactly, an exhibit.
No, but what number are you on?
2, I believe.
Okay. So we can just have it marked, and that's going to be marked just for purposes of the appellate record, not for the trial court record. And you can mark it as defense's appellate 1 if you want to.
Would it be appropriate for me to give this to the court reporter?
Yes.
People don't mind, some people do. If you want to give me a copy of that, I can put it on this computer so that we can just switch it over. But the other way.
It can be for defense's appellate 1.
Okay.
Yes. Because the other one, I think you just marked as defense's 1. So this is just for the appellate record. All right.
Let's make some law, Judge.
All right.
For preserve some.
You let me know when you're ready. All right, with regards to the defense's arguments and the state's argument, the court has heard both. The court has reviewed the case law that has been submitted by the state. The court has also reviewed the brief that was submitted by the defense through email, and that was emailed with the state being included in the email. And I always put that on the record so people will not think there's any ex parte. The court will deny the defense's request. The court is reviewing Brown v. State, 990 Southwest 2nd, 759. Court has also reviewed Belcher, Belcher v. State, Campos v. State as well. All right, other than those objections, are there any other objections to the charge?
No further objections, Your Honor.
All right, so how much time? I believe yesterday you all said you were requesting
45 minutes.
45 minutes per argument.
We request 30, Judge, but if
Don't have to use it all.
All right, so I'm assuming nobody's going over 45 minutes.
Judge club me and drag me out of here.
Okay.
Longer than 45 minutes.
All right, so if what I'm going to do, James Otersdorf, what is happening with your case? Ms. Starling, what is happening with your case?
Judge, I probably need to go to the back and talk to Mr. Baltazar Perez about the offer on his MTR. and see if he's on board with it.
All right, well, we're gonna recall him for tomorrow.
Okay, I'll be here tomorrow.
All right, 9 a.m.
That early? Okay.
Yes.
Okay, that's-
All right. Can I see the file on that? What is happening with your case?
I believe that my client still needs to do the PSI, consent for sentencing. And I still also haven't been able to talk to him tonight.
What's sentencing?
Doesn't matter.
Yes.
I think there's gonna be time long.
Yeah,
So I don't think there needs to be a PSI. I think we
To
just need
picture you.
we can Finish the sentencing, I guess.
yeah, sorry, I'm gonna.
All right, are there any witnesses?
Okay.
All right, let's just bring him out then.
I haven't talked to him in a little bit, though, so I just wanted to like, talk briefly. Could we send him after they close?
Do whatever. I mean, you know, take your time. You want?
Yes. But nobody is leaving this courtroom. Nobody leaves the courtroom again if the deputies have your client. So Mr. Oersdorf, we'll see you tomorrow. Ms. Starling, do not leave the courtroom.
Judge, I needed to also add Mr. Gelman, Gelman. I've conferred with Stacy Harrington this afternoon. But I haven't been able to talk to Mr. Gelman at the jail.
All right, we're gonna bring Mr. Gelman back tomorrow.
Okay, thank you, Judge. Good morning.
You're welcome. All right, and then we will bring the jury. Yes,
Can I go use the bathroom really quick?
yes.
Thank you. I know you said nobody leaves. I want to ask somebody.
Okay.
Talk about reasonable doubt.
Let me come
That's
over.
fine, but reasonable doubt.
You're welcome. And Norma Gelman will be back tomorrow.
We're gonna do that right now. So. Yes, she denied her instructed verdict.
Does anyone want any time announcements?
Sorry,
Any time announcements?
what about our instructed verdict?
Ah,
Yeah.
we will
almost
hear
forgot.
that, but I want your time announcements on your for closing arguments.
Oh, we're gonna want 45 minutes and he'll probably take the majority of that. I'll probably need 15 minutes and give you 30. Is that fair? That's fine.
So do you want me to let you know a specific time? That's what I'm trying
For
to get
me,
at.
for my 15 minutes, 3 minutes maybe.
Okay. And who's speaking first?
Why don't you go first?
I'll go first.
Okay.
Yeah, what about your time limit?
I'd like warnings at 10 and 5.
I usually only do one, but okay.
Okay, I'm sorry.
No, I'll give you 10 and 5.
10's enough.
No,
I
I'll
probably
do
won't
it.
need 5.
How much over any time do we get?
Oh. All right, Ms. Abrams. Gelman is coming back for tomorrow.
What?
And Perez is coming back tomorrow as well.
Couldn't hear. You can speak up. No one's here.
Yes. Consent doesn't mean not coming. If the judge is ruling.
All right, I'm ready to, if you're ready to bring the jurors out. Thank you. State, did you want a time announcement?
Can you let?
Yes, Your Honor.
Gelman is coming back for tomorrow. Yes, the cases have been reset.
Okay, thank you.
You're welcome. I'm sorry,
Can you let Kathy know when she's used 8 minutes?
8 minutes?
Yeah, and can you let me know when I have, I hope I don't get this announcement, when I have 15 minutes left.
15 minutes remaining.
Yeah.
Okay. So basically, on the defense side, Cantrell is using 15 minutes. And Ben, you have 30 minutes. I'm assuming. And does everyone have their equipment working?
Judge, I don't know if they said they might be using a PowerPoint and that we were gonna put it on the computer for them to use, but.
You want to make sure your equipment is working?
Yeah, can you give us another 10 minutes for that?
No, because we're at 3 o'clock and the jury was supposed to be back at 2:45 and the deputy's going to get the jury.
5 more minutes then?
Just make it happen.
All right.
Just one moment. All right, do you have what you need?
We do, but now, do I need to send it to you?
I'll give you my flash drive, you will put it on there, and we'll put it on the computer.
Can we just plug into ours?
Yes, but I'm bringing the jury in because they've been waiting. So if you want to plug it in there, you can plug it in there. If you want to use the flash drive, you can use the flash drive.
Are we gonna do the instructed verdict before the jury comes in, or?
You all have to rest and close
Oh, I
before the
forgot.
jury.
I thought we.
Then we're gonna come forward.
Yeah.
You guys are gonna whisper
Okay.
on whatever you want to put
Sorry.
on the record,
Yep.
and then I'll make my ruling.
Any idea where it goes in here?
Something. Oh, there's an HDMI microphone down there.
Thanks a lot.
Take this out first.
Yeah, okay.
How's it come up? I don't know how you bring it up. You have to come up. I don't know.
We have to switch it over up there.
We just test it.
yours published?
All right, so yours is not working, so you can do one or two things.
We'll
You can do
put
the
it on.
flash drive.
We'll do the
But
flash
I'm
drive.
bringing the jury in.
Okay.
All right.
We should be able. to
Sure
control
you
it.
can.
I won't be able to edit it. That's something.
All right, we can bring the jury in.
Okay. All right, for the jury.
All right, everyone, please be seated. Defense, call your next witness.
Your Honor, defense rests and closes.
State, do you close? All right, defense, do you close?
Defense also closes.
All right, defense and state, if you could approach, please. All right, ladies and gentlemen, both the state and the defense have rested and closed. I'm going to read to you what's now called the charge of the court. And then after I read this document, the state and defense will have a chance to give closing arguments to you. Charge of the court. Members of the jury, the defendant, Alexis Morganfield, stands charged in count 1 of the indictment with the offense of sexual assault of a child, and stands charged in count 2 and 3 with the offense of indecency with the child, all alleged to have been committed on or about the 29th day of March 2020 in Bexar County, Texas. The defendant has pleaded not guilty to each count. 1, our law provides that a person commits the offense of sexual assault of a child if he intentionally or knowingly causes the penetration of the mouth of a child by the sexual organ of the actor. 2, our law provides that a person commits the offense of indecency with a child if, with a child younger than 17 years of age, whether the child is of the same or opposite sex, the person engages in sexual contact with the child or causes the child to engage in sexual contact. 3, child means a person younger than 17 years of age. Spouse means a person who is legally married to another. Sexual contact means any touching by a person, including touching through clothing of the breast or any part of the genitals of a child, if committed with the intent to arouse or gratify the sexual desire of any person. A person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to the circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. 5, our law provides that the time of the offense alleged in the indictment must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by limitation. The phrase on or about means that the state is not required to prove that the alleged offense happened on that exact date. There is no limitation period for the offenses of sexual assault of a child and indecency with a child. Therefore, it is sufficient if the state proves that the offense alleged in each count was committed sometime before February 25th, 2021, which is the date of the indictment, the date the indictment was filed. 6, count 1. Now, if you find from the evidence beyond a reasonable doubt that on or about the 29th day of March 2020 in Bexar County, Texas, the defendant, Alexis Morganfield, did intentionally or knowingly cause the penetration of the mouth of Sarah Funderunu, a child who was younger than 17 years of age and not the spouse of Alexis Morganfield, by Alexis Morganfield's sexual organ, then you will find the defendant guilty of the offense of sexual assault of a child as charged in count 1 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 1. 7, count 2. Now, if you find from the evidence beyond a reasonable doubt that on or about the 29th day of March 2020 in Bexar County, Texas, the defendant, Alexis Morganfield, did intentionally or knowingly engage in sexual contact with Sarah Funderunu, a female child younger than 17 years, by touching part of the genitals of Sarah Funderunu with the intent to arouse or gratify the sexual desire of any person, then you will find the defendant guilty of the offense of indecency with a child as charged in count 2 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 2. 8, count 3. Now, if you find from the evidence beyond a reasonable doubt that on or about the 29th day of March 2020 in Bexar County, Texas, the defendant, Alexis Morganfield, did intentionally or knowingly engage in sexual contact with Sarah Funderunu, a female child younger than 17 years, by touching the breasts of Sarah Funderunu with the intent to arouse or gratify the sexual desire of any person, then you will find the defendant guilty of the offense of indecency with a child as charged in count 3 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 3. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to the defendant. And in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website to include, but not limited to, Facebook, MySpace, LinkedIn, YouTube, or Twitter, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court which is hearing given to you and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching a unanimous agreement, if that can be done without violence to the individual judgment. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you in these instructions, you will acquit him and say by your verdict not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd of the 187th District Court, and suitable verdict forms are attached. State, are you ready to proceed with closing?
Yes, Your Honor. Good afternoon again. Thank you all for your patience throughout the trial and for listening to all the evidence that we presented to you. I know that there was a lot that you had to hear, a lot of sensitive topics. But we really do appreciate you focusing, paying attention, and making sure that you are hearing everything that we came to present to you throughout the trial. So we're here again for this defendant, ALEXIS Morganfield. And we've charged him with sexual assault of a child, indecency with a child by contact for count 2, and for count 3, indecency with a child by contact again. Pictures. Okay. So the elements of sexual assault of a child that we brought to you throughout the trial is on or about March 29th, 2020. ALEXIS Morganfield, this defendant, intentionally or knowingly penetrated the mouth of Sarah Funduriano, a child younger than 17, with the defendant's sexual organ. Second count was indecency. Counts 2 and 3 are the same. The only difference is that we're proving to you that in count 2, he touched her genitals, and then count 3, he touched her breast. And you heard that in her testimony, the different areas of her body that he touched, either with his mouth or his hand. We're only here for the first part of this trial, the first phrase, which is guilt or innocence. We're not trying to talk about punishment anyway at this point. The only topic that you should be discussing when you go back to deliberate is he guilty? Or is he innocent? In this part of the trial, we're not allowed to use any bias, prejudice, or sympathy. The only thing that you should be considering is, did we prove every element to you with the facts that we brought? Do not consider any bias that you had towards the witnesses that we brought, towards the evidence, any prejudice that you might have, and any sympathy that you might have for any witness or any party, defendant, victim. That just doesn't play a role in this part of the trial. So let's talk about what we brought to you. We brought you Sarah to talk about that March 29th is the day that she went out and she met these boys. She got in the car and she made the report the next day, March 30th, later or early that morning. She identified the defendant to you in the courtroom. She said this defendant, ALEXIS Morganfield, was the one that did all of these things to her. She told you that he asked her for sex. She told you that he asked her to do oral, to perform oral. And she told you that he again asked her for sex the second time. We are showing to you that he intentionally or knowingly knew what he was doing. He didn't skirt around what he was asking. He knew what he wanted and he asked her for it. He penetrated her mouth with his sexual organ. Pay attention to these elements that we're asking you to find him guilty on. And nowhere in the elements does it say, did she want to? Consent is not an issue in this case. Why is it not an issue? Because she's a child. She was 16 years old. And there's a reason that our laws create protections for children. Sometimes they get themselves in situations that are dangerous. Sometimes they don't know what they're doing. And there's a reason that our lawmaker said, 16 years old, they don't get to consent. And so that is not an issue here. No matter what defense brought to you about, oh, she wanted to do this, she got in the car with all these gentlemen that she didn't know, doesn't matter. She's a child, consent is not an issue. She talked to you about how he touched her genitals over her clothes. And in the jury charge, you'll find that sexual contact, it means over the clothes also. It doesn't mean just under the clothes, it means over the clothes. And she told you that he used his hand to touch her genitals over her clothes that night. Again, consent is not an issue. It's not in any of the elements of this part of the offense either. the last count, did he touch her breast? She talked to you about how he used her hand, his hand and her mouth, and his mouth, I'm sorry, to touch her breast. And so if you believe Sarah, that she decided to get in the car with these gentlemen, that she went because she was going to smoke weed, that she asked to go home, that she called her mom, that she called her sister, that her friend Brandon picked her up, that she went to her SANE exam. If you believe her on these elements, on these counts, on these facts, then this defendant is guilty. And we believe that we've proven that to you. I want to talk to you a little bit about Sarah's testimony. She was consistent in what she told Officer Sandoval that night. She was consistent with what she told Detective Benavides. She was consistent with what she told the SANE nurse. Every single time she said, yes, I did get in that car. I did meet those boys. I did want to smoke weed. Some of those things you might not admit as a teenager in front of all these strangers, in front of all of these official police officers, in front of a sexual assault SANE nurse. But she did. She has nothing to hide from you. She put herself in this position. She knows it was a dangerous situation, but she still went out. She still got in the car. But she owned up for what she did. She owned up for her mistakes that maybe she made that night. She doesn't have anything to hide from you. She had to come in here and tell you what happened to her, how vulnerable she was, how scared she was. She has nothing to hide. So think about that when you think about the testimony that you heard. She was consistent. She was truthful. She was vulnerable. And think about how her sister talked about that phone call that she had, how she was crying, how her mother talked about the phone call that she had, and how she was crying and she was scared. She was telling the truth, like she told the truth to you when she came in here. And so when you go back there and deliberate, we believe we brought all the evidence you needed to find Alexis Morganfield guilty of count 1, sexual assault of a child, count 2, indecency with a child, count 3, the indecency by contact of the press. And we'd ask that you sign conviction. Thank you.
Okay, please, this honorable court. Yes. Ladies and gentlemen of the jury. Thank you very much for listening to the evidence in this case. Start from the beginning and listen all the way through, and finally get to the end. You heard from my client when he said, "I am not guilty of these offenses." That was the only way that he could have a jury hear his case, a jury of his peers. He said, "I'm not guilty." This is the only way that he can get his case brought forth before you all today. You promised me that the state of Texas has a burden to prove each and every element of their case beyond a reasonable doubt. It's their burden. What we're telling you is we don't believe the state of Texas met that burden. He chose not to testify because we don't believe the state of Texas met their burden. You promised to hold them to each and every element beyond a reasonable doubt. So I ask you to consider the evidence from what you heard.
you consider the reliability of a witness. You heard from Sarah. She claims that that's my client that did this to her. Yet she had never met him before. Only once that day. And those of you might say, well, that's obvious then. It's not obvious. What we know is this. You promised that you would not hold against him if he didn't testify. That's in the jury instructions. And I know you will follow that and not even consider that. But what we do have is this very clear evidence. What do we know about Sarah? Sarah actually learned about Jada King from her stint at the Juvenile Justice Center. She learned about him. She learned about my client, because Jada King and my client were rappers. But here's what we also know. Jada King sent 3 guys to pick up Sarah because ultimately he was under house arrest. Yet she chose to go in these cars, in the car with 3 strangers. And after Jada King decided, he wanted sex with her, but she didn't want to do it, then she basically left the car without asking for, hey, can you help me out? I don't want to really get back in the car with these guys. But she did anyway, because she wanted to smoke weed. So you got to start thinking about, is this a credible witness? Is she embarrassed by her actions? Is she looking for the money? What was her purpose of lying to her mother to go to such extreme, to put herself in such danger multiple times, over and over and over? Next slide. She could have left multiple times, especially that one time when, right before the first sexual acts that she claimed my client, that she performed on my client, that first time, she was outside the car. She went voluntarily in the car with him. She performed oral sex on him without any force. She consented to it. He told that to you multiple times, and she told it to police officers multiple times. State says consent's not an issue, but it's part of the evidence of this case of how everything went down. And you can judge the credibility of the witnesses all the way through based on that. So she didn't know anything about him. She claims that she never saw Jada King until that day, never heard of my client until that day. But it's very clear multiple times, twice for sure, that she consented to go back in the car with him. When he asked to the second time, she said, sure. So again, credibility of witnesses. Asked who she claims is my client, can I borrow the phone to have Brandon pick me up? He calls Brandon. And then when they were going to leave, again, another decision, dangerous decision if you think about it, gets back into a car after they've had sex, oral sex. She still goes back in the car instead of waiting for her friend to come and get her, or going to an apartment and ask for some help or otherwise, if she really felt like she was in danger. This all goes to the credibility of witnesses. And ladies and gentlemen, this is your choice. Is this the kind of person you would want your son or your daughter to go to jail for based on this kind of witness? And you need to really think hard about that, because those are the things you can decide on. How credible is she? How credible is that person? That's this case in a nutshell. She is not a credible person. Next slide. So she went to a store eventually and asked for help. Somebody gave her a phone. They asked her, do you want us to call the police? No. Think about that. if you're that distraught, you thought you were in that much danger, why would you not want the police called? Credibility of the witness. Credibility of the witness. She tells Officer Sandoval, who's the first officer, that, and look, you claim you have all these issues, but you need to go and get a sane result. He tells her you got 120 hours or so to go and get that done. She waits 18 hours. She claims she didn't wash anything off, didn't brush her teeth, didn't take a bath or shower. So all the DNA evidence and everything else should be there. But we also heard from the same nurse, RN Whitty. Been doing it for 35, 40 years. But one of the most important things that she said is I checked her out from head to toe. I didn't see any trauma. I didn't see any bruises. And most importantly, she did the fluoroscopy scope, and I didn't pick up any semen or any bodily fluids. And I submitted it to the for DNA testing, and then I had her look at it, and she confirmed that all the DNA tests were negative. So think of it. I mean, use your common sense. And when I asked her that question about swallowing and spitting it out, I wasn't trying to be funny or anything. I was trying to make a point. You're going to find DNA if somebody ejaculates in your mouth. It's going to be somewhere on your body. All right? Somewhere on your neck. Certainly, if you're kissing somebody, saliva, you're going to find that DNA. It's going to be there. If you didn't wash, you didn't bathe, within 18 hours, you're going to find that DNA. It just wasn't there. And the reason it wasn't there is because he didn't do it. He did not do it. It might be somebody who looked like him, because there's plenty of black men in this city that look just like him. Dregs, his size. She thought it was him, but it wasn't him. Next slide. A second time, Rebecca, his sister, she had to call the police because Sarah didn't want to. All right? Sarah just didn't want to do it. That's also part of credibility of a witness. So, next slide. So let's talk about the police. The person who was driving in that car was a gray Charger. I asked Detective Benavides, well, did you ever check and see if my client ever owned a gray Charger? No. That was easy. I don't know if he's telling the truth or not, because you can easily find somebody. And I tell you, if the state of Texas had checked that and they found that, you would be hearing that. He doesn't own a gray Charger. No evidence is just as much to be considered. And why didn't the state of Texas call the two other people in the car and Jada King? They have subpoena power. They could have made them, they could have dragged him in here and say, hey, and ask those people, was he there that night? They didn't do it. Why? Because it wasn't him. Next slide. What we know about this last situation with Sarah, and one of the reasons I wanted to bring her back again is go detail by detail by detail to show how she is not someone to believe and she's not a credible witness. My client, who is a rapper, all right, who's just starting his business, starting to get all these negative things on his Facebook page and other places that, hey, you're a rapist. you're this and that, you're a horrible person, and then it's getting more and more. So he finally responds to the worst one and says, why are you doing this to me? I didn't do this. And she confirmed that. And then, I feel bad for you, but I'll give you $100 to stop doing this to me. And her reply is, that's not enough money. So there's your motive right there. That's why she did this to him. That's it. That's it. And I'm sorry if she went through all this stuff. I assume she did, but guess what? It's her word. It's her word. My client says it's not me. I didn't do it. And you have no evidence that I did it other than her saying so. But just think of all the things that she said and how uncredible that, not credible that person is. I'm not saying she's a bad girl. Far from it. I feel bad for her. But anyone who makes those kind of decisions, flirting with danger like that, who does that? Who goes in a car with complete strangers, meets some guy who's known to throw out women if they don't have sex with them?
I'm gonna object, that's not an evidence.
All right, ladies and gentlemen, the jury, you remember the evidence as you heard it. Counsel, 3 minutes.
Thank you, Judge. Who does that? Who after you claim that you didn't, that you've had oral sex with somebody, not forcefully, but you're upset about it. And when guy asks him to come back in, says it, sure, yeah, sure. What kind of credible witness is that? Is that the kind of witness that you would want to have someone found guilty of if it were any of your relatives? I submit to you, no. The credibility of witnesses is everything here. You held the state of Texas to a burden that they have to prove each and every element of a case. There's nothing linking him there other than what she says. On someone she claims she's met one night. There's nothing. The police didn't find any videos. They didn't call Brandon. They did not call the worker at the gas station and talk to those people. They surely would have been able to identify those people. Brandon surely could have said, hey, yeah, he called me. Here's his number. There's nothing there. Because it wasn't him. It wasn't him. Don't be so sympathetic that just because of the charge itself and what she's claiming, because you promised you wouldn't do that. You promised. You said you'd listen to the evidence, judge the credibility of witnesses, and we said they didn't prove their case beyond a reasonable doubt. And it's not his burden to do that. And he can decide whether he testifies or not, and you can't hold it against him because you promised you wouldn't. The judge gave you an instruction that you cannot do that. So this is an easy not guilty. Because the state of Texas, maybe because of police work or otherwise, couldn't give him enough evidence. But the most important thing is there's no evidence that is credible. DNA, any other police work, anything to link this man to this crime. And when you think about it, you have no other reason other than to find him not guilty. Thank you very much.
Thank you, Mr. Cantor. I'd like each of you to picture a jigsaw puzzle. You never put it together before. You open the box, probably sealed inside some plastic. Are the pieces? You pour those pieces out on the table. Little by little, you turn them all over to where they're right side up and not on top of each other, and you start building the And then put the border together, you find the four corners. And then it's a 100-piece puzzle. Once you have put about 60 of those pieces in that puzzle, it's still full of holes. Some of the holes are bigger than others. But you walk away and say, I finished. That's the case we've just heard today. I was waiting to hear from Jada King. I wanted to hear from him. Did he know Sarah? Did anything happen? How much of the story is true? How much of it is, I mean, is this totally 100% a novel? Is it based on actual events? I would really like to have heard from Jada King. Did Sterling introduce Sarah to Jada King, otherwise known as Jaden Green? Did he introduce them? I don't know. I didn't get to hear him say it. Brandon. I never got to hear a thing from Brandon. Did Brandon get a phone call? If he did get that phone call, what was that phone number from? Did he go somewhere and meet Sarah? Did he take her home? I would have loved to hear him say that, but I didn't. Again, more holes in the puzzle. We have 3 people who supposedly were in a car with Sarah. And yet I have not heard a thing from the other 2. If there were 2 other witnesses who were with Sarah, then they would certainly know who else was there and who else was not. But just as I see that empty chair, I'm reminded we didn't get to hear from them. Were they real? I don't know, because I didn't get to hear. Did Sarah go through something that night? There's reason to believe she did. But there are huge gaping questions. The 7-Eleven employees, I would have liked to have heard at least one of them sit up in that chair and say, yeah, she came in. Who was she with? Well, we didn't get to hear that because they never got identified. Surveillance footage from 7-Eleven. SAPD says we never got it because maybe we forgot to ask for it in time and then it was too late to ask. More evidence that could have been enough to clear my client's good name. Gone. Nothing. My colleague has gone into a lot of detail regarding some of the witnesses you've heard of, or you've heard from in the last day. I had a couple of thoughts that I wanted to share. Mine will be much shorter, I promise, on that. We know that Sarah was between 16 and 17. There's no reason to doubt that. We know that Sarah had been in alternative school because she admitted that on the stand. We also know that she had been in juvenile justice academy, which she also admitted on the stand. We have not gone into why she may have been at either of those schools or what has happened. I've heard that she is in community college now. And I would like to say that I wish her well, but it is hard to say that I wish someone well when they are more than willing to send an innocent man to prison. If anything, I will say she's gone through a lot. A lot of it appears to have been through her own decisions. There was a lot of talk about what may have sounded like consent and what she may have been willing to do and who she may have been willing to go with and how much danger she was looking for, this much maybe, but not anymore. Willing to get into a car with strangers with no phone so that she could go use drugs with somebody she never met. consent is not an issue. When the state tells you that, consent is not an issue. For reasons in this case, the only age that matters is the age of 17, and she had not attained that age. So she is still a child from the law's point of view. So instead of all of these factors about her going to consent, I would argue that they go to credibility. She admitted that she was willing to lie to her mom in order to go use drugs with a rapper that she'd never met, who she knew through a student in alternative school, who she also later testified that she couldn't contact that person, Sterling, because apparently Sterling was in jail by that time. Again, goes to credibility. I was expecting a little more emotion. I was expecting something. I don't know quite what I was expecting, but what I got is somebody who didn't have a real good grasp on the facts and did not seem emotionally connected to what she was saying. Somebody who had trouble testifying consistent with other statements that she made in the past. So I don't really know which ones are correct and which ones are not. It's hard to know, but what we do know is that the life of a young man hinges on whether what she says is true and reliable. And that's a very, very heavy weight. And I was expecting a little bit more connection, a little bit. I don't know what I was expecting, but I was expecting more. We heard from several witnesses, including Officer Christian Sandoval. He's the one who recommended go do the SANE exam. You have up to 5 days to do it. As you know, DNA negative, sperm negative, semen negative. There is no more biological evidence that was on Sarah at the time of her SANE exam to point the finger at my client than there was to point the finger at me. When she talked to Officer Sandoval, she conveniently left out the part that they were going to smoke weed and that they bought weed. How do you tell that to a uniformed officer? So let's just kind of cover that one up. But later on the phone with the detective, it's a little bit less personal. Yeah, we were going to get weed. We actually got weed. And oh yeah, he touched me under my clothes. Yeah, two different versions of a story. Was the first version correct? Was the second version correct? Or do we have none of the above? There is a presumption of innocence at the heart of our legal system. It sets a bar like a pole vaulter has to go over. And there are a lot of different bars. They talked at the beginning, the state talked about preponderance, about clear and convincing. The highest bar that we have in the law is beyond a reasonable doubt. That the case against any criminal defendant, every single element has to be proven enough to go over that highest bar. And when you think of that, I want you to picture a pole vaulter clearing that bar. Their case has to clear that highest bar without making the bar fall down. If it doesn't, you are not declaring a verdict of innocent. You are simply declaring a verdict of not guilty. Did the state's case cross over the bar without knocking it down, or did it not? We also talked about that the presumption of innocence alone is enough to acquit a person if the state has not made its case. And I would want to make sure, if any of my kids were ever on trial, that their jury would be very, very careful and would not ignore the presumption of innocence and just vote for the best story, but actually ask, did the state meet its burden of proof? simply because the life of somebody that I love and care about depends on it. And God forbid, someday maybe somebody that you love could be accused and you would want the same for them. We've talked about the issue of race, and that is not as big a concern in San Antonio as it would be many other places. San Antonio is a very diverse community. However, there is still the idea of us and them from the way that we've grown up. We grew up with us. We learned that there is a them. We learn not to be rude to them, but we are us and we are not them. And when you're deliberating, I do want each of you to ask yourself, would I have any different opinion if every single word that I heard this week was about a white defendant and a black alleged victim, simply to make sure that nothing that has ever happened in your life is somehow clouding the way you look at this or putting this in an us and them type of perspective? There is a right to remain silent. It's one of our Bill of Rights. It's the Fifth Amendment. No one can be called to testify against himself, and that's been taken to mean nobody can be called to testify at his own trial. We've heard a lot about what Alex may or may not have done. I wanted to hear Alex say that he was not guilty. And the very first morning of trial, I heard that. He stood up, I stood up, Mr. Cantrell stood up. The court read him each of the 3 counts and asked how he pleads. And I heard him say not 1 time, not 2 times, but 3 times, not guilty. I want to hear that. I hope you were looking at his face when he said it so that you could see that he believed his answer. Each of you is a judge. When you go back to the jury room, there will be 12 judges in that room. Normally in the court, there is 1 judge. And 1 judge is usually plenty, but not in this case. In the case of a jury trial, we need 12. Because somebody's future, somebody's life is hanging in the balance. We need 12 people, each saying, I'm ready to put the brakes on this if my heart isn't in it. If I don't believe that the state has met its burden of proof, if I don't believe that the state has proven each of the elements of each of these counts or any of these counts beyond a reasonable doubt, I'm willing to be the one who votes not to convict, who votes not guilty. And if I believe that the state has not met its burden of proof, or if I have what I believe is a reasonable doubt, and you know what is reasonable, I believe all of you believe that you are reasonable. I'll talk about that in just a minute. You need to be willing to be the one. And if you are part of the 11, please respect that there may be one whose heart is instructing them, and that pressuring them to change would be wrong. So we ask you to consider, please talk to each other. But if you are convinced that the state has not met its burden of proof, or that a reasonable doubt has arisen in your mind as to my client's guilt, I need to know that all of you are willing to be the one, and that everybody else is willing to respect that. The word reasonable doubt, we cannot define it, but the first word reasonable comes from the root word reason. And I mentioned this when we were talking about picking a jury 3 short days ago. 2 short days ago. Wow, it's been quite a whirlwind week. It was Tuesday and it's just Thursday. It's been quite a week. Reasoning is what makes man different from a lot of other creatures. They have some reasoning capability, but not like we do. We have the ability to put our minds to work. We have the ability to look at things skeptically. We have the ability to question things. We have the ability to keep asking questions until we get the answers that we need and until our curiosity has been satisfied. and what I asked you at the beginning of this process is that each of you would put in the mental exercise to make sure that all of the details got noticed. Even if it was missing details, I want you to notice that too. If there were things that you wanted to hear this week that you didn't get to hear, I want you to notice that and I want you to think about that. It comes back to a story. When a defendant is not guilty for the simple fact that he didn't do it or he wasn't there, the story is going to be a very short story. Because it starts out, once upon a time, I wasn't there. I didn't do it, the end. And that's not going to make for a good movie. A good movie is something that can fill an hour and a half to 2 hours, have some drama, have some pitfalls, have some thrills. But at the end of the day, when you get done watching a movie, you turn off the TV and you get back to what's real. What we've heard this week has been a novel. It may be based on some true events. Is there a Jada King? Is that Jada King Jaden Green? Maybe. Did we get to hear from him? No. Are there some true events that some of this was based on? Does she live in Helotes? She said she lives in Helotes, I believe. She says that she went to some other side of town. I don't know whether she did or not. I don't know if the characters in her story are real. I don't know if she went through something traumatic or not. If she did, I don't know who was there. Because what I do know shows me that I cannot trust just her for details that I can believe, that I can stand on. Definitely not enough to send a young man to prison with a conviction for sex offense. Thank you for your time and for your attention this week. This will be the last time that the defense gets to talk to you. We appreciate your attention. We appreciate your time. We appreciate you being here every morning instead of whatever the next best thing is that you have to do. It's a very big sacrifice to be a juror, and you get paid almost nothing to do it, which I'm sorry for, but it makes me all the more grateful. So thank you for doing this. Thank you for considering the future of a young man. Thank you for considering whether you heard enough or not. The state has a high burden. Hold them to that burden. And when you've done that, and it's time to end the movie, to end the novel, you've read the last page, you shut the book, you put it back on the shelf, knowing that it's just a pretend story, you go back to what's real. Find Alex Morganfield, non-guilty on all counts.
Thank you, Your Honor. We are here today not because of what Sarah did or didn't do. We're here today because of what the defendant did do. We are here today, we're not here today just because the victim's white. We're here because of what the defendant did. We're not here just because the defendant is black. We are here because of what the defendant did. So, I want to talk about, first of all, the law in this case. These are the elements that the state has to prove beyond a reasonable doubt. This is count 1, which is a sexual assault of a child. But on or about March 29th of 2020, Alexis Morganfield, this defendant, who for some reason, there's no evidence contrary or evidence to suggest that this is not Alexis Morganfield, intentionally or knowingly penetrated the mouth of Sarah Funadirianu with the defendant's sexual organ. So, what do we not see in there? Whether there was any lack of consent or consent, right? The defense wants to tell you that we are here, the state's going to say that consent is not an issue. No, the law given to you by this judge that you are to be governed by tells you that consent is not an issue. I'm not telling you that, the law is telling you that. Count 2, which is the indecency with the child. But on or about March 29, 2020, the defendant, Alexis Morganfield, intentionally or knowingly engaged in sexual contact with Sarah Funadriano, a child who was younger than 17 years of age at the time of the offense. There's no evidence otherwise or contrary or suggested that she is not a child by touching part of her genitals with the intent to arouse or gratify the sexual desire of any person. And then count 3, the exact same thing except for touching of the breast instead of touching her sexual organ. So each and every element the state has met beyond a reasonable doubt in this case. What we experienced on this was basically a case from the defense perspective in, I would say it's a case study in victim blaming and victim shaming. What could she have done differently? Well, she couldn't have gone that day. She could have not got into the car with the 3 individuals. She could have left the apartments and found somebody. What does that have to do with our elements? What does that have to do with what we have to prove to you beyond a reasonable doubt? What they want to do is say, they're not going to go ahead and say it, but I'll go ahead and summarize it for them. Well, she knew what she was getting into. Seriously? What does it have to do with our elements of the offense? What does it have to do? They want to say it's consent, but that's not an issue in this case. So when we talk about sexual contact, there's a definition provided by the court and in the charge. And that is any touching by a person, including touching through the clothing of the breast or any part of the genitals of a child, if committed with the intent to arouse or gratify the sexual desire of any person. What do we know about sexual contact in this case? Alexis Morganfield is rubbing her vagina while he's kissing, right, in the back of the car. After he just had repeatedly asked her to perform oral sex on him, obvious it's his intent to gratify his sexual desire. What do we know about when he's kissing her breasts and pulling up her shirt? We know all those same things exist, right? It's clearly sexual contact. So what are not elements of the offense? Any issue of consent, right? I know I'm kind of beating a dead horse, but there's a reason for that. And Cassie already touched on this. And part of this is through Sarah. And Sarah explained to you and demonstrated that for you. Our law protects children because children sometimes make bad decisions. That's why children cannot consent, right? Because children sometimes, unfortunately, despite parents, siblings, and instructions from authority figures, make bad decisions. But her bad decision doesn't allow this defendant to sexually assault her. That does not give him a pass on touching her vagina. That does not give him a pass on kissing her breast and touching her breast. What also do we have to prove? That Alexis Morganfield knew Sarah. There is evidence, though, to know that, right? We know that he was friends with Jalen Green, who was brothers and went to school with her, right? Clearly, he knows the age of the child. So we'll go witness by witness and talk about what they proved to you. So let's first talk about Sarah. What motive does she have to lie or fabricate a story? What motive does she have to lie to have to go to get a SANE exam, to have a complete stranger look over her naked body, to have to take medicine and have to take anti-nausea medicine because of what the treatment that she goes through? What motive does she have to come here and tell you, 12 complete strangers, and sit in front of the person who committed the offense against her and tell this story? What motive does she have to lie, or what's demonstrated a motive to lie when she's telling you all the things that are not necessarily good about what she did, right? She's the one who tells you, yeah, we went there, we were going to go smoke weed. She also tells you that I got in a car with 3 people I didn't really know because I was gonna go hang out with this Jada Green guy, right? If she's gonna lie, why not make it a better lie? Why not? Yeah, I knew these people. I knew these people I was gonna get in the car with. Don't even mention the weed, right? But what does she do? She's honest with you. She's candid with you. And she gives you the stuff that necessarily might not be what she wants her parents to hear, her sister to hear, for the public to know. So again, I think her coming here and telling you all of those things demonstrates her credibility in this case. Again, the defense spent a lot of time of like, well, you could have gone here, you could have talked to these other people. What does she tell you about the circumstances surrounding this? I don't know where I am. I have a phone that doesn't work. Who also, there's 2 other witnesses, her mom and her sister tells you she had a phone and you have to have Wi-Fi to work. I have nobody that I'm with. What is she's with 3 complete strangers, males, in an area of town that she doesn't know, late at night. What is she supposed to do? If you were a kid in that same situation, I don't know what I would do. I don't know if I wouldn't go in a car and hopefully find somebody better, somewhere I could talk to somebody, somebody where there would be somebody at to hopefully get myself out of that situation. If she was trying to get out of trouble or get something out of it, why would she immediately have to call her mom and her sister to tell them? And obviously she's very emotional. Both of them told you she's sobbing on the phone. She's clearly emotional. Why would she call them if nothing happened? She needed to fabricate a story. Doesn't make any sense. So next we'll talk about is Christian Sandoval. The reason we call him is just to kind of give you a timeline and also talk in context so that when she testifies, she's flat, right? The same nurse told you that she was flat, but she also gave you a reason why she's flat. That is common in these types of cases and common in victims like this. Then we have Linda Whitty, the same nurse. Has performed, I think she said, over 1,350 SANE exams. A lot of SANE exams. And she tells you about all the things that come with the SANE exams. So we're talking about, again, somebody looking over her naked body, taking swabs of her body, having her repeat the things that happened to her, having to take prophylaxis, these medications that would make her nauseous, right? If you're just going to make this up, why not make something up that you didn't have to do all of those things? She also told you about the flat affect, right? That's pretty common in these cases. It has to do with their biochemistry and their reaction to trauma. But I think what the most important part of her testimony is that, to kind of summarize, is no DNA, no problem. Based on the timeline that she's given, about 18 hours afterwards is when she sees her. Not necessarily when she goes to the hospital, but that's when she sees her. So remember, she has a medical exam before that. Is that she's not going to expect that in this case. Talks about the ejaculation in her mouth. Mr. Cantrell wants to suggest to you that, oh, well, it'd be all over her body and all of these things. Linda Whitty, who's an expert, is telling you that that's not the case. It's this defense attorney who's representing his client, the centrist, is trying to tell you otherwise. But you heard no evidence otherwise. Then we had mom and sister testify, Eureka and Rebecca. Mom tells you that I see my daughter leave. It's not like she's necessarily sneaking out. I just see her go. She's going to go hang with friends. I'm waiting up for her. And that's when eventually I get a call. Who does she say she gets a call from? Brandon's phone, right? Brandon, who she knows from her neighborhood, and that Brandon is the person that brings her home. Well, how in the world did she get a hold of Brandon and if her phone's not working, right? She clearly called from another phone. So that kind of is part of why she testified. And I'm gonna kind of skip ahead a little bit and talk about the witness that you notice that Mr. Stevenson and Mr. Cantrell never mentioned in their entire closing, and that's Veronica Barta. He's like, all we have is her saying these things happen. No, that's not true. We actually have Veronica Barta who comes in, who's the pretrial supervision officer, the state's last witness, who said, oh yeah, he told me without response to any questions, how is it an assault if the girl went down on me? But obviously they have nothing to say about that because how do you get around that? He's
Objection, Your
telling
Honor. She
you-
said that she had no idea in what context he was talking about.
All right, ladies and gentlemen, the jury, you will remember the evidence as you heard the evidence presented.
Again, tells you how is it assault if the girl went down on me? What do we know about the facts in this case? It's oral penetration, it's penis, right? Clearly, he's admitting to what he did.
Objection, Your Honor. There was no evidence to say that he admitted that whatsoever. Matter of fact, he admitted that he wasn't the person.
It's a legal
And
objection.
and she said that too.
Ladies and gentlemen, the jury, you will hear the evidence as it's been presented.
He's gonna want to interject, but this is clear. He's admitting to what he did. So, Detective Benavides, he tells you kind of his investigations. He tells you that he tried to follow up with the gas station. It's not that they didn't, that they had surveillance showing that this didn't happen. It's just by the time that they got there, their surveillance was no longer there, and that they talked and they were unable to figure out which clerk was working that night. It's not that this evidence necessarily wouldn't exist, it's that they couldn't figure it out, right? It is not inconsistent with Sarah's statement about what happened. And what is he telling you? I reviewed the report, I reviewed the saying, I reviewed the video, case exhibit number 5, which defense objected to, as well as my interview with every witness. What is it? It was consistent all the way through. And what does he do based on that whole investigation? He tells you, I have some options, right? I don't have to necessarily file a case with the TA's office, but I did, right? Because we are here and we're prosecuting the case. So the evidence in this case, it's clear, almost certainly uncontroverted. And we have brought you Sarah, who, again, and when I say, well, we could have brought the 3 people in the car. Well, what do we know about Jalen King? He's on an ankle monitor. So let's just think here. If he's on an ankle monitor, probably has a case pending, right? So do you think he's going to be coming here and testifying? Probably not. Also, what are they going to tell you about what happened in the car when these 2 are the only people in the car? Remember what Sarah told you? The other 2 guys, they were out of the car. I couldn't even see where they were, right? So what are they going to tell you? She's in the car? Okay, that again doesn't go to the state's case in the sense of, does it prove or disprove any of the elements of the offense? No. So what we have here is a clear case of sexual assault of a child and 2 counts of indecency with the child. Want to talk quickly about what's not evidence. So this is part of your jury instruction that statements of counsel made during the course of the trial or during the argument, if not supported by evidence or statement of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. What that means is if I say something that's not a fact, then it's not evidence. If they say something and assert that it's a fact, that's not evidence. The evidence is what came from that witness stand and what was admitted into evidence, okay? Arguments about the law. Law is given to you by the court. We are making arguments about the law. So that is your roadmap to what, into looking about and determining whether somebody is guilty of the offense. And it shows you each and of the elements within the paragraph. So what I say, what Mr. Cantrell says, what Mr. Stevenson says, that's not evidence. That's not necessarily the law, right? These are arguments. So remember what came from the witness. again, this case, the state has clearly met its burden beyond a reasonable doubt. There's instructions in there that Cassie talked about. Do not let bias, prejudice, or sympathy take part in your deliberation. That's what I call the but if clause. Well, the state met each of the burdens beyond a reasonable doubt, but he's a young guy. That has no role right now, okay? That might be very relevant for punishment and determining punishment. That has nothing to do with the state's elements and whether the state has met its elements. Okay, so right now, what you're instructed to do, what the court is instructed you to do through the jury instructions is to go back there, deliberate, determine whether the state had met its burden onto the elements of the offense. And I submit to you that it clearly has. And I'm hopeful that each and every one of you will be unanimous and that this defendant sexually assaulted Sarah Funariano and that he committed the offense of indecency with a child by 2 different ways, counts 2 and 3, by touching her vagina over her clothing and her breast, and committed the offense of indecency with a child by contact, and that you find him guilty on all 3 counts. Thank you.
All right, ladies and gentlemen, the jury, I kept telling you I would let you know when it was your turn or your time to deliberate. Now is that time. I'm gonna have the deputies take you back. I will need Daniel Neal to remain here with us, please. And everyone, please rise for the jurors. Right, everyone, please be seated. And Mr. Neal, if I can see you outside. And if anyone would like to speak to Mr. Neal, then you're more than welcome. And then, should I have them find for the Starling out?
Yeah.
That is Jesse Martinez, and I will be right back. Okay?
They have ways of forcing people to come here under subpoena. They could have still got Jordan Green here under subpoena. He could have pled the 5th, but he would have still been here, but they didn't even try. And that's why I emphasize that. I don't know. I don't know why. I don't know why she'd want to hurt you. And I pity whatever happened to her to make her into who she is now, but I'm sorry for anybody who's trying to send an innocent man to prison. I feel sorry for them at all. What? Get a 2-word verdict. You walk. 1-word verdict, be bad. 1-word verdict, and then we got to transfer her on probation. But 2-word verdict, and we're done with this trial. Their case had problems. Their case definitely had problems. Whether it was enough is a question the jury has to answer. Well, there is a lot of witnesses that could be called, but in this case, I would argue that they should have called a lot more than they actually did. So I don't think that they did a great job on this one. Mhm. Now, as you know, okay, well, hopefully the jury will agree with you. We're gonna hang around for a bit, and then I don't know what time the judge will send them home for tonight. It is 4:25. So okay. But I'll hang around here till the jury gets done deliberating for the evening, and then I will be around. I will either be in court or within 5 minutes of court if they come back tomorrow. In my opinion, the longer they take, the better it is for you. If it's quick, it may not be. The longer they take, that means you got somebody on your side and they're actually thinking it over.
All right, y'all ready to proceed? All right,
Your Honor, could I ask a question?
yes.
What is your standard practice? How late do you generally expect juries to deliberate into the evening, just so kind of have an idea where you're at?
sleeping bags if you need them.
That was funny.
Yeah. And we, of course, this is the 187, so we always have snacks in the back.
Gotcha.
Healthy snack, healthy snack.
Okay, they're not healthy food snacks. But, and if you need a snack, you're more than welcome to partake.
That's fine.
Sure.
Wondered what to tell my wife. Well, the jury has to judge if the witness is reliable witness. She was reliable. Mhm. And hopefully the jury, at least the reason 12 of them is if they're getting lied to, at least somebody should realize, hey, this doesn't sound, this doesn't add up. This doesn't feel right. This doesn't pass the sniff test.
Oh.
Or at least if we kept them from proving there is not enough. We don't have to prove innocence. We just have to prove the state did not meet its burden of proof beyond guilt, reasonable doubt of guilt.
So. That's exactly what I'm talking about. I'll tell you, every single time. Like, oh, it's like, I'm gonna, except for one.
All right, the court is going to call 2021 CR 4749, State of Texas versus Jesse Martinez. Can I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Happy Starling.
And are you Mr. Martinez? All right, this was originally set for hearing Oh, that's okay. This case, just a second. Deputy, that's okay. Deputy, there is one of the jurors who's there. And I don't know if he received his excuse or not. All right. All right, we're back on the record. Mr. Martinez, you were originally scheduled to be here on June 18th, but you were a no-show. It was scheduled for 9 a.m. and you were a no-show as late as 11:01 a.m. Is the state still proceeding with the offer that was made? Because according to the plea bargain agreement, punishment was to be assessed at 4 years in the prison. And part of the offer was if the defendant is not present on the date of the sentencing hearing or is charged with any new cases before the sentencing date, he will be subject to the full range of punishment.
That's correct, Judge. And defense counsel and I discussed his failure to appear, and we have a new agreement that we would propose to the court. And we're asking that he be sentenced to 6 years TDC, and the rest of the agreement remain the same.
All right, is that correct, defense? All right, Mr. Martinez, you understand that the agreed offer of 6 years is what the new agreement that your attorney and the state have come to, but that the court could sentence you to 20 years and still follow your agreement. Do you understand?
Yes, ma'am.
All right, why were you not present?
I was working with my uncle, and then my grandma got sick, and we buried her.
Oh, no, you couldn't pick up you didn't have the phone?
I wasn't thinking on it.
I'm sorry?
I wasn't thinking. I was. Not only that, yeah, I was also, I was doing drugs when everything was happening. That kind of got deeper into it.
All right, the court will sentence you to 6 years in the prison. Give you credit for any time served. There's $1,000 fine, time and money to run concurrent. Take in consideration 2020 CR 2599. If you would like, I can request the therapeutic community for you. The therapeutic community doesn't increase the amount of time that you will serve. You will still serve at most 6 years, but it's possible for you to receive treatment through the therapeutic community. Would you wish to be considered for the therapeutic community?
Yes, ma'am.
All right, so when you go there, you'll have to request it. I have no authority to force them to give it to you, but if you do not request it, they will not. Do you understand?
Yes, ma'am.
Is there anything else with regards to sentencing from either side?
Just a dismissal, Judge.
All right, Mr. Martinez, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. You're gonna have to do better. How old are you? We're off the record.
I'm 41.
All right, you're gonna have to take care of your sobriety. If you don't, nothing good can happen. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, ma'am.
All right, you're welcome. So Ms. Starling, how are you enjoying your new job?
Well, I was at the public defender's office in ALEXIS County, right?
Mhm.
And I was tempted to set it up there, but I left we knew Walt was left in January, and I
Oh.
actually left in April. Sometimes I feel like county should go up with defense, or maybe it's more about the contract and about quality defense. And at my worst, about 180, and at my best, about 135 felonies. And that would be only 50% of it. That was also a situation. So it's hard to look somebody in the face and say, well, the offer is 30 years and you're facing life in prison. And I have about 2 hours to work on your case. So we do like a jury trial and very close, right?
yeah.
I got used to saying when I'm in Berry County at George.
So are you back in solo practitioner or?
So have you jury with Operation Start?
Yes.
So I am contract attorney through the local private defender's office. We just had the very first hearing in Denver County. And so we, with my client, who's on the bond, and so we did a equal protection hearing for it. Me and an attorney named Keller.
Okay.
They're only arresting men under Operation Love. And so hopefully we did a good preservation and
Well,
my first
Well,
criminal court of appeals. I'm gonna file it on Friday for.
all right. Well, I'm glad to see you back. I'm sure everything's going to go fine. I always say people just bloom where you're planted. So I'm sure you're blooming.
I'm actually, I just got married. January,
Oh, congratulations.
July.
Congratulations.
So, then moving, at the end of this month, actually, yeah, so, Mr. Martinez got picked up, and then one of my other clients who I lost got picked up, and so I was like, oh, I'm just gonna be able to resolve them.
Yeah.
Like this.
Well, do not be a stranger though, even though you're in Utah. Of course, you're always welcome in the 187.
Yeah, I'm gonna come back and visit, because I gotta come back at least every other month for our video stuff,
Okay.
or.
Okay. All right. Good seeing you. Have a good one.
I wonder if it's gonna be fast, I might hang out for another half hour. or something.
Okay, sure. All right. Thank you.
I'm sorry, what was it called, the therapeutic community?
Therapeutic community.